Good morning. Welcome to House Judiciary. Here, you want to call the roll?
Representative Brady.
Excused?
Representative Breton.
Here.
Representative Chestick.
Here.
Representative Feiler.
Here.
Representative Kelly.
Here.
Representative Lean.
Here.
Representative Singh.
Excused?
Representative Webb.
Here.
Chairman Washed.
Here.
You have a quorum.
Thank you. So we have hopefully 3 bills we'll get through today. We'll start with Senate File 7. Senate File 7, Protection Order Amendments. This bill, members, came out of the joint interim judiciary work of the 67th. The goal here dealt with streamlining some of the language so that the language on protection orders as it relates to sexual assault and stalking was more aligned with the language of protection orders as they pertain to domestic violence. So we have 2 different sections of statute that provide for 2 different types of protection orders. And the goal was to try to make these things more consistent with one another. And so what you have in front of you in the engrossed bill out of the Senate is a product of 3 interim meetings where we heard lots of testimony. And so if we just walk through the bill, you'll see in section 1, we reference those 2 different sections of statute. Those that are in Title 7 pertain to stalking and sexual assault. Those that are in Title 35 are those that deal with domestic violence. And we go to page 2, we define court, and we also indicate that where the victim or the offender resides will be the county, the court will be of the circuit court in that county where the act of stalking or sexual assault occurred, or where the alleged perpetrator resides, or where the victim is found. And then we go down to 73507, line 15 on page 2. We start clarifying the language, a petition that may be used by the petitioners, changing which to that, not a big change. And then down on line 19, if the petition is not filed by the district attorney, the court may appoint an attorney to represent the victim in the action. It used to say an indigent petitioner. He ended up jumping through a bunch of hoops to determine whether the victim was indigent or not. And finally they said, most of these cases, the district attorney is filing those things, but if not, we'll just appoint an attorney if they need one. It's not usually that expensive to assist them to get that paperwork done. And then on page 3, we're still in Title 7, an order of protection granted under this section shall be filed with the clerk of court, and a copy shall be sent to the clerk and county sheriff, who shall after service notify local law enforcement agency within the county in which the petitioner resides. The order shall be personally served upon the respondent unless the respondent or the respondent's attorney was present in court when the order was granted. Then line 17 through 20 at the end, subject to the following restrictions. The order of protection is granted by the court for an effective period of time not to exceed 3 years. Either party can move on line 22 to modify, terminate, or extend. And then on page 4, some new language starting on line 4. Any extension of an order of protection under this paragraph shall be served to the respondent by mailing the order to the last known address of the respondent on file with the clerk of court. As a condition, most of these folks are ordered by the court to maintain that address with the court. And so if they move and they haven't maintained that address, the court is allowed by this language to send that to the last known address that was on file with the clerk of court. And that's considered lawful service. Then a new section 2, starting on line 11. If a party subject to an order of protection is sentenced and incarcerated, this is where we get into tolling, where the protection order is held in abeyance during a period of incarceration and then pick up where you left off. So if they had 6 months left on their protection order when they went to prison, when they get out of prison, they have another 6 months still waiting for them, right? And then on page 5, we have some new language. The court means the circuit. This is when we get into Title 35, where we're talking about the domestic violence protection orders. We have that same language about the court means the circuit court in the county where the alleged victim of domestic abuse resides or is found, where the alleged perpetrator of domestic abuse resides or is found, or where an act of domestic abuse occurred. And then we get down on line 16. The following persons may petition the court under this act, filing a petition with the circuit court clerk for an order of protection. So the victim can file on the bottom, line 22, then you go to line page 6. If the victim consents, the district attorney can file for the protection order on the victim's behalf, or on line 4, any person with legal authority to act on behalf of the victim if the victim is a minor or vulnerable adult or any other adult because of disability or health or inaccessibility, so someone else can file on their behalf. Then we strike some language on the bottom of page 6 and insert represent the victim in the action. Nothing in this subsection shall prevent the victim from hiring an attorney or filing a petition pro se. So the individual can have an attorney appointed to help them with this work. Then on page 7, an order of protection granted under 3521-105 shall be filed with the clerk of court. The order shall be personally served upon the respondent unless the respondent or the respondent's attorney was present in court when the order was granted. Same language as we had in the other section pertaining to sexual assault and stalking. And then on the bottom of the page, again, subject to the following, we have a 3-year maximum on our protection orders. Section I on page 8, either party may move to modify, terminate, or extend. Any extension of the order shall be served upon the respondent, or unless his attorney is present or he's present when the order is granted, or it can be mailed to the last known address that's on file with the clerk of court, and all that would count as a valid notice. And then on line 11, section 2, if the party subject to an order of protection is sentenced, we get into the tolling process again. And then on page 9, the act shall apply to petitions for stalking, sexual assault, or domestic violence protection that are filed on or after July 1, 2025, and the effective date of the bill, July 1, 2025. And that is Senate File 7. Anyone in the room wishing to? Good morning, Ms. Butler. Can you fill in some gaps for me there?
Good morning, Mr. Chairman, committee members. My name is Elisa Butler. I'm the State Court Administrator for the Wyoming Judicial Branch. Mr. Chairman, I think you did a superb job of explaining the bill, but I'd be happy to answer any questions that any of the committee members may have.
Can you explain what prompted Senate File 7?
Mr. Chairman, absolutely. So one of the things that we experience in the circuit courts is protection order cases tend to be very process difficult for our clerks. So the process of getting those, it's not so much the award or the granting or denial of a protection order, it's the process that goes along with that. So what really prompted this was the idea that we wanted to make a little more streamlined process for our clerks. And one of the ways to do that was to try to marry up the language in Title VII, which deals with stalking and sexual assault protection orders, and Title 35, which deals with family violence protection orders. Those two titles have different language currently. And so one of the ways that we try to make things a little more streamlined as we process these kinds of cases is to marry up that language and ensure the process is very similar regardless of the kind of protection order that is being requested.
Representative Kelly.
Thank you, Mr. Chairman. When I was first introduced to this topic, there was, I caught wind of the idea of periods longer than 3 years, if not permanent. Is there some insight as to why that idea does not appear to be in the bill, or did I just miss it?
Ms. Butler.
Mr. Chairman, Representative Kelly, that was a topic of conversation with the interim Joint Judiciary Committee, was to create a permanent protection order in certain circumstances. There was actually a bill draft that was introduced this session, and it began in the Senate, and I think it failed to come out of the Senate Judiciary Committee. So the bill, the idea is out there, it just didn't make it through the process this time.
And I might add that the whole purpose there was to deal with the tolling challenge. That when people go to jail or prison, the time that the protection order is valid is stayed, so that then it picks up where it left off, basically. And that becomes, it's not as big a problem for the Department of Corrections if somebody's in prison for 2 years. But when people are in and out of jail in different counties, trying to keep track of how many weeks have they been incarcerated and how much time do they still have left on their protection orders gets problematic. And so one solution was offered up by Judge Christensen, I believe, was that other states, some of them have permanent protection orders for, and I think the big concern there is kind of off of this bill, but was whether or not, if you were not convicted of a violent felony, might that interrupt somebody's firearms rights indefinitely. And so I think that was part of the challenge with the permanent protection order. That follow-up, Representative Bratton?
Thank you, Mr. Chairman. I have a question on page 4, starting in line 18, where it talks about upon release from incarceration or imprisonment, the effective period of the order of protection shall be the amount of time remaining. So if somebody has 1 month left, let's say, left of the order, they're in jail, and then they get out, instead of the 1 month that they had left, now, since it's 1 year or greater from the time of release, so now they have a year, even though they only had 1 month left
Yeah,
on
that's
their sentence, and then
existing
it's a
law.
year. I'm sorry.
That's existing law, Representative Bratton.
Right, I was just curious if I was understanding that correctly. It's just my question.
And I think that's to allow for notification of the victim that the offender is getting out of prison, and to not, let's say they only had 5 days left when they got out, then the victim would have to get back into court and file for an extension within that 5-day time period, or the protection order might expire. So the existing language in statute is 1 year.
All right, thank you for explaining that.
Did I get that right, Ms. Butler?
Mr. Chairman, I believe so, although, yes, I think that's right, although Ms. Chambers may also be able to comment on that.
Oh, I got it. All right. Other questions? All right. Anyone else in the room wishing to testify on Senate File 7? Thank you, Ms. Butler, for getting up early and being here with us. Nobody? Okay. Anybody on Zoom for 7? All right, going to close public comment. Committee, what's your preference? Moved by Chestick, second by Webb. Discussion on the bill or amendments? Going to be an easy one. Representative Webb.
I'll ask one question, Mr. Chairman. Sorry about that. Are you and the previous committee content with everything that's in here?
Yeah, I'm pretty comfortable. I think the committee worked the bill pretty diligently over the interim. It sailed through the other end of the building. I'm pretty comfortable with this bill. All right, anything further? Call the roll.
Representative Brady,
Excused?
Representative Bratton,
Yes, aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excused, do pass.
Any volunteers to carry it on the floor? Representative Singh. Very good. That takes us to Senate File 8. Senate File 8. So you notice that Senate File 8 comes to us on a white piece of paper. That means there were no changes made to the bill on the other end of the building. This too was a interim committee topic. And what we're looking here is issues related to the service of the orders. And so if you look, the meat of the bill's on page 2, line 1, an order of protection granted under this statute shall remain effective during the pendency of an appeal or review of the order of protection or any decision to modify or extend the order of protection unless the court orders a stay during that pendency or appeal or review. So this makes it clear that the protection order remains in effect unless the court says otherwise. And then on section F, line 12, an order of protection granted under this act shall remain effective during the pendency of any appeal or review of the order of protection or any decision to modify or extend. So this is taking the same language that was in lines 1 through 6 that applied to Title VII under sexual assault and stalking. And then on this second piece in F, we're applying the same language to those protection orders granted for domestic violence under Title 35. That's all this bill does, is make sure that it's clear that these acts remain in place during appeals and so forth unless the judge rules otherwise. That's the bill. Getting some head bob back there, and pretty simple, clean. Any questions on the bill? Anybody wishing to testify on Senate File 8? Representative Lean.
Mr. Chairman, I'm just curious why we're addressing the same titles, but they're in two different bills. Senate File 7 also addresses these titles, so I was just curious why they're two separate bills.
Yeah, slightly different purpose. One was just dealing with the appeals and making sure that they're clear during that time frame, where the other was really structurally cleaning up the language, make it more consistent between the two titles. Probably could have been crafted in such a way, but just the timing of discussions during the interim, we got two separate bill drafts, and that was just kind of the track we ended up on. Any testimony in the room on Senate File 8? Seeing none, going to close. Anybody on Zoom? All right, I'll close public comment. Committee, what's your preference? Move the bill by Filer, second by Lean. Discussion or amendments? Seeing none, call the roll, please.
Representative Brady,
Excused?
Representative Bratton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Lean,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washut.
Aye.
8 ayes, 1 excused, do pass.
All right, do I have a volunteer to carry this heavy lift on the floor? Representative Bratton, thanks for stepping up to the plate. Senator Craigo. Members, we're now at Senate File 79. Senate File 79, I believe Mr. Nicholas is online. You want to bring him in? Do you want him with you on the presentation? Senator, we're all yours.
Thank you, Mr. Chairman, committee. Barry Craigo, Senate District 22, which I'm still getting used to saying that. It's a little bit odd after serving with you and you for quite a while. So today I bring to you Senate File 79, District Court's change of venue. This is as you can see, it's a two-pager. It's a pretty simple little bill. It really is relating to, and specifically deals with change of venue in district court in civil cases. Recently, well, not recently, a while back, the Supreme Court issued a decision that said if the legislature wants parties to be able to change venue without losing their filing date, we needed to pass a law to do that. And so that's what this is attempting to do.
Senator, can you explain what a change of venue is?
Absolutely, Mr. Chairman. So when you file if you look through your green books, you have to file in a particular venue, depending on what type of case. There's lots of different reasons, and those are all set out in Title I's Chapter 5, and there's lots of different places you can file venue. Occasionally, you end up filing in the wrong venue. And that's what this bill is attempting to do, is solve that problem. If you file in the wrong venue, what is the court to do? And right now, the court typically, pursuant to a motion to dismiss, filed by the defendant, would say, hey, you're filing in the wrong venue. Court would dismiss that, and then you would refile. What this bill does is allows the court to transfer you to a different venue, to the correct venue, without losing your filing date, which is important if you're up against the statute of limitations. And so that's really all the bill does. The first part of the bill says, talks about creates the opportunity or the ability of the court to change venue. The second part, paragraph B, talks about the savings clause. Essentially, it says whenever you filed in the first venue, that's your filing date. And then part C, which is the only reason it's on a blue sheet instead of a white sheet, we added rulemaking authorities so that the courts can actually implement this rather than us trying to create the system. It's better left to them. This gives them the statutory authority to address the problem and do it in their rules. It's pretty simple. I think former President Nicholas probably can add some more color to it, but that's what the bill does. Happy to answer any of your questions, Mr. Chairman and committee.
Questions for Senator? And the color commentator on Zoom?
Thank you, Mr. Chairman. Mr. Chairman, I think the only thing I would add to what Senator Crago said was
Would you
that
please introduce yourself for the record?
I will be happy to. My name is Phil Nicholas. I'm an attorney here in Laramie, Wyoming. And, over time, we kind of try to identify bills where there's traps for people. And this is one where we're trying to fill a trap just to make sure that nobody gets harmed. But the only thing I would add is that on venue, what you're really talking about is the 9 judicial districts. So if you're living in Laramie County, for example, you live in Cheyenne and you're involved with a car accident, and suppose you're injured in Sweetwater County, but the trucking company is from out of state, and you determine that you want to sue in Sweetwater County in that judicial district, a motion is filed that there's no jurisdiction because the trucking company doesn't reside there, and you have to file the action in your hometown county, which is Laramie County. Well, traditionally you have to then refile, then you have to go out and get service on the trucking company. So it might have been difficult to get service on the trucking company in the first action. That might have taken you a couple months, cost you couple $100 getting service completed, and then by moving to dismiss, the trucking company gets a benefit. What this allows, Mr. Chairman, is for the court to say, well, we're going to just allow you to transfer the case back to Laramie County. You will have to refile it there because remember, we're now having electronic filing. And so part of the reason why the Supreme Court wants to have some jurisdiction over it in rulemaking is because they'll probably require you to refile a filing fee in Laramie County. But nevertheless, when you file in Laramie County, you get the same service. So you don't have to reserve the defendant after having served him in the first action. The time for filing the complaint would be the same. And you just move on. It's more timely. I think it's a good case for Wyoming, or a good statute for Wyoming citizens. But the only thing I'd add again is really you're talking about within the judicial districts, and that's what the venue is. Mr. Chairman, I'll stand for questions if anybody would like to ask questions.
Thank you. Questions from Mr. Nicholas? Representative Kelly.
Thank you, Mr. Chairman. So just to clarify, what we're doing here is just an added administrative step, but we're saving the plaintiff the hassle of starting all over.
Mr.
Yes,
Nicholas.
Mr. Chairman.
Okay. Representative Lean.
Thank you, Mr. Chairman. Thank you for appearing today. My question comes on page 1, line 12. It says that the courts may on its own change the venue. My question is about notification. Is that to be brought forward in the rules, or is there somewhere in statute that it says how that notification would happen to the petitioner?
Mr. Nicholas.
Mr. Chairman, all orders are published now. Of course, once you are a party, the court publishes it. It's unlikely that the court would ordinarily the court would give you notification of its intent to transfer and give you an opportunity to be heard. I suppose technically a court could summarily do it on its own, but it's unlikely that would happen. But in any event, there's always notification, as the notification of last resort is an order. But generally speaking, the courts operate by rule proceedings, and under rule proceedings, the court would give a notice of intent to do that on its own first, give parties an opportunity to be heard.
Follow up? Further questions? Seeing none. Thank you, Senator. Anyone else in the room wishing to testify on Senate File 79? Good morning. Haven't seen much of you this session.
No, I don't know if that's a good thing or a bad thing. Good morning, Mr. Chairman. My name is Beth Lance. I'm here on behalf of the Wyoming Trial Lawyers Association, and we are here today to support this bill. This bill seems small, but it creates great efficiency for those whom it may affect. And so it certainly is just one of those spots, I think, in the law that have been overlooked, and this bill looks to correct that, to allow a more simple transfer of these cases in the event of an incorrect venue filing. It saves money and time, and it certainly can keep someone's case on track. And again, be able to avoid any harm to a plaintiff who may have a good case, but is potentially up against a statute of limitations. And in that event, this could save them from being kicked out for that timeliness. And so if that exact transfer, being able to allow them to continue on that same clock that they had started.
Questions from Ms. Lance?
Thank you very much.
Always good to see you.
You too.
Anyone else in the room? Senate File 79. Anybody else on Zoom? I'm going to close public comment. Senator, you want any final comments?
No, sir. Thank you, Mr. Chairman. Thank you, committee.
All right. Committee, what's your preference? Moved by Filer, second by Kelly. Discussion on the bill or amendments? Question being called. Call the roll.
Representative Brady,
Excused?
Representative Breton,
Aye.
Representative Chestek,
Aye.
Representative Filer,
Aye.
Representative Kelly,
Aye.
Representative Ling,
Aye.
Representative Singh,
Aye.
Representative Webb,
Aye.
Chairman Washet.
Aye.
8 ayes, 1 excused, and pass.
Senator, do you have preference which of your co-sponsors carries the bill for you on the floor? That it'll be. Very good. All right. Well, that concludes our workday. Committee, I do have a question for you. As we wrap up the session, we need to have a joint meeting with our Senate counterparts to discuss interim topics. And what was the date that the Senate suggested? Monday, March 3rd at noon. So there won't be any bills for committees that week, so it should be wide open. Do any of you know of a personal conflict or some reason why Monday at noon wouldn't work? So Pierre, if you would let the Senate know that that will work for us Monday, the 3rd at noon.
Mr. Chairman.
Mr. Vice Chairman.
Thank you, Mr. Chairman. So there may be a conflict with the Education Committee, but we'll work that out with the folks organizing that.
Please do. And let me know if you just can't make it work. I want you to be there.
We'll be here, yeah.
All right.
Claim the date first.
Yeah.
So on interim topics, individual members can suggest interim topics. Members of the public can enter suggestions for interim topics. And I'm being told by the speaker that there's a desire that management council play a little softer role in the process of picking interim topics, which should benefit the committees to exercise some judgment about what we'd like to do. So one of the issues for us is we'll have one meeting in Cheyenne and one meeting in Casper, and then we'll pick the third site. And sometimes we pick that third site based upon topics that get selected. So for example, let's say we took up a topic of forensic examination of prisoners at the state hospital. We might want to have a meeting in Evanston and actually tour the state hospital facility as part of that meeting. But we could pick any other topic, and we may want to be in Rollins and tour the prison, or it may not even be a topic, but there just may be an area of interest among the committee that never been to a prison. It'd be interesting to go take a tour of a prison. And so we could pick a site based upon the desire of the committee. So give that some thought as you're thinking about topics, but also think about areas of interest that you would like to learn more about, things in the purview of the Judiciary Committee. Okay. With that, we'll stand adjourned until Friday morning.